Hello, my name is Josh Blackman, and welcome to the 2022 Harlan Institute Ashbrook Virtual Supreme Court Competition. I am pleased to welcome to the team for the semifinal round from Austin, Texas, Campbell Collins and Gabriella Lovins. And from Chicago and New Jersey, we have Jeevan Tarsney and Jack Tarsney. And this is the semifinal round. Petitioners, we begin whenever you are ready.
May it please the court. My name is Campbell Collins, and along with my co-counsel, Gabriella Lovins, I represent the petitioners, Students for Fair Admission, in today's case.
The University of North Carolina employs affirmative action to give certain races a benefit that other races do not receive. This program violates the 14th Amendment and Title VI. It is unconstitutional for three reasons.
First, because there is not sufficient historical justification for this type of program. Second, because Grutter v. Bollinger, which allowed for limited race-based practices, should be overturned because it does not align with the 5 factors laid out in Dobbs, and because UNC doesn't even try to follow its guidelines. And third, because affirmative action policies violate strict scrutiny, or do not meet the level of strict scrutiny.
So first, this law or this practice has no historical precedent. There are 2 types of laws that appear to deal with race in history. First, there are laws that appear to provide a race-based benefit, but actually work in a race-neutral way. And second, there are laws that clearly harm minorities and are unconstitutional. So a good example of the first type of law, a law that appears to be race-based but works in a race-neutral way, is the Freedmen's Bureau Act. The Freedmen's Bureau Act provides food, clothing, and shelter to freedmen, their families, and war refugees. This can appear to be race-based, as all freedmen were former slaves who were Black people. However, it works in a race-neutral way because while all freedmen were Black, not all Black people were freedmen. It's focused on your legal standing as a former slave rather than your race. And this law doesn't.
Counsel, if I can interrupt for a moment, but I'll take your point of the Freedmen's Bureau Act, but there's some other legislation, for example, the creation of universities and otherwise, that were fairly race conscious. They mentioned colored, which was how we referred to race back then. How do you address those statutes?
So there are some laws that appear to be race-based. Most of these, when you look into them, show that they are actually working in a race-neutral way. And as Justice Scalia put it in City of Richmond v. Croissant, these laws were undoing the effects of past discrimination in a way that does not involve classifications by race, despite racially disproportionate impact. Sometimes these laws, such as I believe DC, created a law providing some financial help specifically for Black people. This appeared to be race-based, but the issue was only Black people in the District of Columbia at this time lived in such deep levels of poverty. So rather than providing a benefit to one race over another, this is working to target the group who is specifically struggling under.
So let me ask you a question. North Carolina has a history of very bad race relations. There was Jim Crow, there was segregation. Couldn't this policy be used as a way of saying we're trying to help deal with our history of punishing people because of their race?
Well, no, Your Honor, for a couple of reasons. First, because affirmative action policies are not narrowly tailored enough to specifically deal with people who have been directly harmed by previous racial legislation. Under these policies, you can receive an admissions benefit just by checking a box without describing any situations that were specific to yourself and your specific experiences. Secondly, in other cases, this court has decided that remedying past social discrimination is not enough of a justification for race-based policies.
Right, so I get that. So you're saying this is not a remedial case. The only interest that the university can achieve is the educational benefits and diversity. Is that right?
Yes, Your Honor, that was the justification in.
And you want us to get rid of that one, right?
Could you repeat that, Your Honor?
And you want us to get rid of that interest altogether, to say that Bakke was wrong, Grutter was wrong, that there is no compelling interest to achieve educational benefits from diversity. Is that what you want us to do?
No, Your Honor. There is an educational benefit in diversity. However, this law, this race-based affirmative action policy fails strict scrutiny because we can achieve that compelling interest
Oh, so
through
you agree
non-race.
it's compelling. So you stipulate that interest is compelling. So you're arguing it fails in narrow tailoring.
Yes, Your Honor. And it fails narrow tailoring because Fisher 1 told us that strict scrutiny imposes on the university the ultimate burden of demonstrating before turning to racial classifications that available workable race-neutral alternatives do not suffice. And we've seen.
Do we have to? Do we need to overrule Grutter then? If, in other words, if we maintain that there's a compelling interest here for diversity, do we have to overrule Grutter?
Well, yes, Your Honor, because Grutter doesn't satisfy the 5 factors laid out in Dobbs for determining whether prior precedent is good enough precedent to be continued to be followed. And there are 5 reasons why that's the case. First, the reasoning in Grutter is not just wrong, it's egregiously wrong. It goes directly against Brown v. Board's precedent that there is no authority to use race as a factor in affording educational opportunities.
Counsel,
I'm sorry, go ahead. My colleague, please.
Counsel. So to just talk, specifically about UNC, and your brief mentions that there's a checkbox on the application that requires an applicant to identify their race. If we agree that that checkbox should be removed, and then the next class of students at UNC were all white, would that be okay? And should we not remedy that?
Well, Your Honor, that's an extremely unlikely scenario based on what we've seen in other states. For example, when Oklahoma banned their race-based admissions practices through a constitutional amendment, they found that diversity of all different racial groups actually rose. And additionally, we're not saying that the University of North Carolina doesn't have the authority to use a student's experiences, which may be based on their race, to make their admissions decisions. For example, if a certain student tells a story about their cultural heritage and how that has affected them, that would be a permissible way to admit that student. However, we're just saying that the university does not have the authority to base admissions decisions based on race, which it does.
I have a question for you about that, is going back to the Freedmen's Act. It's not necessarily because they were African-American, it's because they were once enslaved. And what you're saying here is that the students could write an admissions essay saying, it's not because I'm this race, it's because I've had, this past, this history, these life experiences. But doesn't that kind of just put us back in the same scenario? I mean, you can guess based on where someone comes from, their religious practices, things like that, what race they are, right? So now you're just back to square one, grouping them by race, admitting them by race. So what do you say to that?
Well, Your Honor, it's not about keeping your race a secret. It's about focusing on the characteristics that you show and the ways that you've overcome diversity, the ways that you dealt with a socioeconomic status that's a little maybe lower than the average. So universities can absolutely look at these things. What they can't do is put students into buckets that they may or may not, and prescribe them characteristics that they may or may not have. They need to show their characteristics in their application, and race does not have to be a secret.
And this is one reason why Grutter is so internally contradictory. On the one hand, it says that we need racial diversity in education because it prevents stereotyping and shows that students shouldn't be classified based on the race. And on the other hand, it allows universities to use race as a proxy for education, for experiences, for beliefs.
Counselor, let me just ask you a question. Let's say you win, right? We overrule Grutter, we do everything you want. And in 5 years, the university comes back and says, look, we did everything we could. We looked at socioeconomic, we looked at everything else. And our class is basically a bunch of white and Asian kids. We have, in a class of 1,000 students, we have 5 Black kids. Does that change your position? Does that do anything? Does that make any difference to you?
Well, Your Honor, at that point, the university might find that they have satisfied strict scrutiny and that they might have enough legal justification in order to enact a race-based policy if Grutter is not overruled. However, we are not at that point yet.
We're asking to overrule Grutter. So let's say Grutter is overruled. Is it the answer that you can never use race-based classifications?
Yes, Your Honor. The university can enact other policies such as
But
policies.
what if those other things don't work and we have advocacy from California telling us it won't work? What if it won't work?
Well, Your Honor, we've seen that most schools are able to work with this. So we at least need to explore these options more than we have, because we can't use race-based options until we've exhausted these options. And Oklahoma, for example, has had incredible success with all levels of diversity increasing after they constitutionally banned race-based admissions. I see our time is almost up. May we conclude?
Please.
In conclusion, the 14th Amendment protects all classes equally and does not permit one group preferential treatment. We pray that this court will reverse the decision made by the lower court, overrule Grutter, and grant the petitioner's appeal.
Okay, thank you so much. Thank you, petitioners. All right, respondents, you have 15 minutes. Begin whenever you're ready.
Thank you, Mr. Chief Justice, and may it please the court. My name is Jack Tarsney, and along with Jeevan Tarsney, I represent the respondents, the University of South Carolina. The Equal Protection Clause of the 14th Amendment was intended to allow race-conscious legislation on behalf of underrepresented or persecuted minorities. First, the Equal Protection Clause permitted race-conscious legislation as a form of remediation. Since the passing of the 14th Amendment, Congress has attempted to aid certain racial groups through legal action. This legislation can be viewed during the Reconstruction period following the Civil War, where legislation was passed to help freed African-American slaves, as well as after Reconstruction to help multiple other minority groups. An example of this would be the Freedmen's Bureau, which was sponsored by the same groups of Republicans that drafted the 14th Amendment and helped aid freed Blacks with money, land, education, and support following the war. The petitioner believes that the Freedmen's Bureau was not race conscious because it helped freedmen and not Blacks. This is incorrect. While it was labeled to help freedmen, the Reconstruction Congress anticipated the effects of the Bureau, which helped a vast majority of Blacks. Furthermore, the aid Congress was willing to give to free Blacks far exceeded the money the Bureau provided for refugees. Even if the Freedmen Bureau's acts were hypothetically considered not to be race conscious, other racial remediation legislation explicitly referred to color. When Congress created legislation to protect the rights of, quote, colored women and children, helping aid them with relief money, land, and other resources. These acts were intended, quote, for the relief of freedmen or destitute colored people in the District of Columbia. This legislation expressly referred to color in the allotment of federal benefits. While the petitioner argues that all Reconstruction legislation provided one group with something another group already had, they are incorrect. While Congress provided Black troops regiments with chaplains and additional funds to be put towards education, white troops remained an unfunded optional service. This displays how race remediation was taken past race neutrality. We agree with the petitioners that some Reconstruction laws.
If I could jump in, so you said the 14th Amendment was intended to help the government, help underrepresented minorities and other persecuted minorities. How do you then understand Justice Harlan's dissent in Plessy?
Well, Harlan's dissent in Plessy doesn't hold that the Constitution's colorblind, and Harlan's dissent does not hold that, well, it was not, Harlan's dissent in Plessy was not confirmed by Brown, so Harlan's dissent is not confirmed to be correct.
So you think Harlan was wrong?
Sorry, excuse me?
You think Harlan was wrong in Plessy?
Yes, slightly. Obviously, race discrimination against and segregation is wrong, but Harlan's dissent that the Constitution's colorblind is also wrong. And just because Brown found that Plessy was wrong, doesn't mean they found Harlan was right.
The Supreme Court has cited Justice Harlan's dissent favorably many times. Does that not do anything? Does that not matter?
Well, you see, it matters, Your Honor, it matters to some extent, but it matters because that was, prohibiting discrimination. Just because Justice
so I can ask this question, you're okay with racial classifications that help certain minorities. You're just not okay with racial classifications that hurt minorities. Is that your position?
Correct. When race is used to help someone up out of discrimination for remediation, race it can be used under the watch of strict scrutiny. But when it's used to push someone down or to create,
but let's just be a little candid here. When you have an entering class, let's say 1,000 students, there's a fixed number of seats. If you're giving a benefit to some people based on their race, people who are not of that race are getting a detriment, negative. You can't. It's a zero-sum game. So anytime you use race help one, you hurt another.
Well, this actually race is used a lot less than most people would think.
He has to ask the question. I mean, but in a hypothetical question, if you're admitting one person because of their race, a person not that race is not being admitted. One gets a benefit, one gets a burden. So I don't know if the distinction you draw is so neatly divided.
That's true. There are certain cases, less than 1.2% of cases would hurt one group while helping another. Otherwise,
1%. I mean, so we're allowed to discriminate for 1%. I mean, what's your? In other words, if you're saying Harlan is wrong, you're always going to have a situation where at least someone is hurt because of a racial preference.
correct. But if for example, if other solutions were used that did not account for race, some minorities would not be offered the chance to participate in the educational benefits of diversity and be allowed into these institutions, as remediation gives them a chance to be able to
And
do
I'll
so.
ask a question for your partners. We can make sure to keep it balanced. Does UNC justify their policy based on remediation?
UNC uses their policy, well, as we said, very rarely it comes down to race, but they do it in a way that is meant to promote diversity.
Right. So
And
is UNC arguing based on remediation?
no, I don't think so, Your Honor.
So all this stuff about remediation, is it really relevant to your argument here?
No, Your Honor, it's not.
Okay,
And if I may, Justice Blackman,
please.
what is your goal here? What is your remedial goal, right? What's the critical mass you're actually trying to reach? Have you guys established that?
Well, you see, there's the critical mass. We don't have a number for that, but there will come a point in time where racial classifications won't be needed anymore.
And what is that point in time? How are you measuring that?
Well, I think that point in time comes when enough of the class is of a minority to achieve diversity. And I can't speak to when that time will come right now.
So do you have a range? Would it be when 15% of the class is diverse, 20, 50? Would it take 51%?
I think it would take somewhere from like 20 to 30% of the class to be part of a underrepresented minority to achieve some form of diversity. But that is specific to each school and each, who the school is, accepting, and their range of students and how many of them are underrepresented or not. So it's specific to each school. So I can't speak to, what number exactly is going to qualify for diversity.
So, counsel, petitioner mentions there are race neutral options that UNC can adopt to achieve racial diversity, which is UNC's goal. Why doesn't UNC just adopt one of the more race neutral options?
Well, the UNC has shown and tried these race neutral solutions, and they found that it doesn't create that same compelling interest of diversity, because the district court found that UNC had tried to use these solutions, and they had not worked to the same extent that race does. They had not created the same, diversity and inclusion that race can provide if used.
Okay, so what exactly is diversity? What does diversity mean to UNC? Because to me, it looks like you're just looking for racial diversity, but there's other ways to be diversity, like the diversity of religion, diversity of political belief. To me, it just looks like UNC has a checkbox for race so that the admissions office can sort applicants by race. How do you respond to that?
Well, I would say that while it can look like UNC just checks boxes for race and only uses race to qualify for diversity, there are other types of diversity that are worked into the holistic approach UNC uses, right? So as UNC looks at a candidate fully, race is one factor, not a dominant factor, but one factor they use. Other factors are going to include social economic background, other stuff like that can help provide a holistic view of a candidate.
Well, counsel, let's talk about stare decisis for a bit. Your friends on the other side say that Bakke and Gruder should be overruled. Can you please address that argument?
Well, we believe that Grutter should not be overruled, because both stare decisis and Dobbs include that something needs to be egregiously wrong and something needs to have no reliance interest. And we hold that Grutter is the accepted practice in admissions and has contributed to reliance interests. The petitioners argue that because race can't be used under the 14th Amendment, race-based admissions programs have not generated reliance interest. However, we've already shown that race can and has been used under the 14th Amendment. So that means that the public and private universities everywhere that implement Grutter's decisions would be affected if Grutter were to be overruled. And these show reliance interests, as well as Grutter is not egregiously wrong because it complies with the 14th Amendment and it complies with other.
All right, well then, all right, let's say we agree with you. Let's say that we don't overrule Grutter today. And let's say we rule for you. And what happens in 25 years, you come back and you say, Your Honor, we still need more time. And then in 50 years, in 100 years, will there ever be a stopping point where you will no longer need racial preferences?
Yes, I think there will. There will be a point, I can't say specifically when, but there will be a point where diversity will be reached and the numbers will keep gradually increasing fairly until we've reached a level where the compelling interest of diversity is not enough anymore to overweigh strict scrutiny.
All right, may proceed.
All right. So I would like to bring up some cases outside of remediation legislation, such as Yikwo, where a Chinese man that was not a U.S. citizen was discriminated against by the state government. And the court found that Yikwo and, quote, Chinese laborers or any Chinese of other class deserve compensation for these wrongful political actions. This demonstrates.
I mean, the other side cites Yikwo for a very different reason, that Asians are being discriminated against. Is that the best precedent for you to cite here?
I mean, well, Yikwo can show two different things, right? It can show that Asians were being discriminated against, but it can also show that they received compensation, which is similar to remediation, right?
But again, is there remediation here?
I think there was remediation because the court
Is UNC relying on the remedial effort, the remedial justification?
yes, UNC is relying on race remediation as a justification for
I
their
think
system.
your colleague said they were not relying on remediation. Maybe you could just clarify what your position is on that.
Well, our main point is that the 14th Amendment was intended to allow race consciousness on behalf of underrepresented minorities for remediation.
No, I get that, but is UNC, the University of North Carolina, relying on remediation as an interest?
I think, yes, they are. They're relying on
I don't think
remediation.
they are. I think they've disclaimed that. In UT Austin, they're not relying on remediation. I mean, do you have in your brief City of Richmond versus Croissant? Have you familiar with that case?
I don't believe so.
Okay, that's fine. You may proceed.
Okay. There's also examples of Indian law that exemplify race consciousness past the Reconstruction. And this court stated in Rice v. Cayetano that it has established that Congress may fulfill its responsibilities to the Indian tribes by enacting legislation dedicated to their needs. This includes treaties securing fishing rights, federal jurisdiction over crimes committed by Indians, distribution of tribal property, Indian immunity from state taxes, and other stuff that can show race consciousness as an example of race consciousness within this court.
Mm-hmm.
If I'd like to move on to Grutter and show how Grutter isn't egregiously wrong. I think Grutter does not meet the criteria of either stare decisis or Dobbs because it's not egregiously wrong. The framers of the 14th Amendment considered colorblindness and proposals that would make the 14th Amendment colorblind. Quote, no discrimination shall be made by any state. This was a proposal that was ultimately abandoned. And instead, the 14th Amendment adopted equal protection of the laws.
Counsel, you say in your brief that Grutter cannot be overruled unless it does not danger reliance interest. How do you respond to petitioner's argument that many states have already gotten rid of race-based admissions processes and instead offer race-neutral admissions, and they seem to have the same outcome? Doesn't that go against your argument that universities have a reliance interest in keeping admissions race-based?
Yes, it does. And just because other universities have found some sort of success with race neutrality doesn't mean that UNC in their situation will be able to. It also there are other public and private universities that have used Grutter consistently to in as reliance interests because race can be used under the 14th Amendment, and they have been using it for 2 decades now.
How do we determine which universities can easily switch to race neutral and why can't North Carolina? What is that factor that makes it easier for some states and not others?
Well, for some private universities, they have the luxury of being able to take really whoever they want. North Carolina has to take in-state students, and every university is different with the field of applicants they receive. So every university is different with who they choose to accept, and all these different factors can kind of change each university, make every university different in their. Can I wrap up real quick?
Yes, you can finish your sentence, please.
All right. So I also want to look at the facts of the case real quick. Well, the petitioner believes that.
I think just one sentence.
Okay. We urge the court to uphold the decision of the Fourth Circuit and rule in favor of the respondents.
Okay, thank you so much. All right, 5 minutes for the petitioners, whenever you're ready.
May it please the court. Respondents' arguments fail for 3 reasons. First, because UNC doesn't follow Grutter's guidelines and respondents misrepresent what UNC is actually doing. Second, because there's no historical justification for race-conscious remediation. And third, because respondents refer to a nebulous concept of racial remediation that's not supported in historical or constitutional precedent. First, UNC doesn't follow Grutter, and respondents misrepresent what UNC is actually doing. Grutter refers to a concept of a critical mass, which, according to testimony by UNC employees and experts, is not a concept that they deal with in their admissions office. And in fact, they're not even sure they would know what a critical mass means. Additionally, Grutter indicated that there was a time limit on race-based admissions, whether that was a holding or just dicta. That was still an idea in Grutter that's not present in UNC's policies. In fact,
but you know, maybe the fact is that we were perhaps optimistic that race relations would improve, and they simply haven't, and there's still a need for affirmative action a quarter century later. Why couldn't the court find that today?
Well, Your Honor, when we look at what other universities have been able to do to achieve similar and sometimes higher levels of racial diversity, we see that we can achieve that same interest of supporting race relations.
Is it the same interest? Because we have amicus briefs piled this high saying that they can't achieve the same numbers.
Well, Your Honor, when we look at other states that are doing this, we see that they can. We mentioned Oklahoma before, but it is such a fantastic example of what we can achieve when we create a different standard that doesn't categorize kids by their race, but by their whole person. And
all right, counsel, let's say we rule in your favor, right? Just assume, and we want to write the opinion. What test should we give about how universities can consider race? What fill in the blank? What do we write? How would you frame the test?
Universities cannot consider race as a determinative factor in
Determinative.
admission. Yes, Your Honor.
Wasn't what Grutter said? It can be one of many factors. Isn't that consistent with Grutter?
No, it's not consistent with Grutter, because Grutter also has these other concepts of a critical mass and
so what if you write race cannot be determinative, but race can be one of many factors, period. Would that satisfy you?
Well, Your Honor, that would follow Grutter's holding, but that would still be unconstitutional because race is still being used as a decision point.
Oh, okay. So again, fill in the blank. Race can be used blank. What opinion should we write? You tell us.
Your Honor, race cannot be used in admissions.
Period. 0. So if a student writes in his essay about his race, do we just knock that out? We can't even look at it. We just redact it.
Your Honor, you can look at that insofar as it is an expression of an individual's specific experiences, but not as you cannot make an admissions decision on that applicant based on their race, but you can based on their experiences.
But then what do we tell admissions officers? I mean, we actually have human beings who have to read these essays. What advice we give them that if a student wants to write about his race, about his, his parents, immigrant story from a third world country, or how he suffered discrimination on the school bus, or what do we do with that information? Do we just exclude it? Do we not consider it?
Absolutely not. That should be considered. That's a part of this applicant's story, their personality, their characteristics. It's not putting them into a bucket, saying that this is their race, therefore we infer these things about them. It's the student telling you who they are.
Why is that different than Grutter? It's one of many factors. Isn't this going back to a holistic approach to the person? You sound like you're saying, you're not using the word holistic, but it sounds like you're saying holistic.
Well, Your Honor, because the specific guidelines that Grutter has provided are simply unworkable in practice. They have this concept of a critical mass that UNC doesn't even try to use.
Your standard is one of, but again, so what is your standard? You said race cannot be used, period. I think that's what you said. And then, except it can be used like this, right? What is the standard you would give us?
So the difference between reading an essay about their racial experiences and checking a box is that an essay is about their experiences, and checking a box is just inferring something about their person because of their race. They can talk about their race when telling you about themselves, and then you're not giving them a benefit on their race, you're giving them a benefit on talking about their experiences. So it's an individualized person. And I see our time is almost up. Maybe conclude.
Please.
In conclusion, we ask that this court grant the petitioner's appeal and overturn Grutter. Thank you, Your Honor.
Okay, thank you so much. All right, bravo. Bravo. The other team can please come back on camera. You guys just walked into buzzsaws, right? I wanted you to know the sorts of questions that Kathleen and Dallas and I were asking were the same sorts of questions you get in law school. We were merciless, we were very harsh, but I hope fair. I don't know, maybe you disagree with us in that last part. But we tried to simulate what a super hot bench looks like, and I think you withstood it. And you did things I really appreciate on both sides. Your pacing was good. Your diction was good. You didn't panic. You didn't get excited when we started asking hot questions. When we interrupted you, you stopped talking, which I know is hard. It's something that I struggle with myself. But it's very important that when you stop talking, you listen to what the judge is trying to say. Also, I know that for the Jeevan and Jack, you're in different locations. It's also tricky to sort of hand off one to the next. I thought it was actually pretty smooth when you handed it off. That's good. Colin and Gabrielle and Campbell are in the same place, so it's a little bit different. Also, I think you had a strong command of facts. You had a strong command of history. I think you came off as genuine and sincere. It didn't seem like you were forcing it. It seemed like you were just being who you were, which is, I think, very useful. I have some particular feedback in a moment, but I want to give Kathleen and Dallas a chance to have some feedback as well to share with you.
Not much particular feedback. I think overall, just like Professor Blackman said, you all did great. I think you'd all make wonderful law students. Campbell and Gabriella, you guys did an amazing job of answering every single question. You didn't try and dodge it, try and answer a question you weren't asked to get around it. You answered the question you were asked. And Jack and Jeevan, again, like he said, being in different places, you had excellent teamwork. It was really seamless.
Yeah, I echo everything that Judge Blackman and my co-judge have said. I think that you all did a really great job staying calm under pressure. I also think respondent side, you guys did a great job of conceding when you needed to. That happens a lot, and you just have to do it. And I also think you all did a great job of sticking to your argument. You didn't kind of waver or change your mind. You just said, this is my argument, I'm sticking with it. So you guys all did a great job.
Very good. Let me just give you some particulars. So for respondents, Jeevan, this is a point that not everyone agrees on, but some advocates say don't use your hands, which is very hard. I don't know what Kathleen and Dallas think, but I think from the East Coast, right? You sort of, your hands go up.
I use my hands.
Oh, no, you're the Chicago one, I'm sorry. Keep your hands in the podium, because it can be distracting because you're kind of going like this and you're sort of counting at times. The hand can be a little bit distracting. For Jack, the question of remediation, I think you have to get on the same page, because I think I think at some point Jack realized that UNC did not argue remediation. And I know that Jeevan got that, or at least he didn't, because you said the opposite, right? Because I was pushing Jack on, is this remedial? Is it remedial? And then she said, no, it's not. And that's correct. UNC is not relying on remediation from segregation or slavery. They're relying solely on the educational benefits from diversity. And the city of, the case you need to know is City of Richmond versus Croson, Croson, case in the 1980s. And the court held that even though the city of Richmond had a long history of segregation, that history wasn't enough to justify a racial preference policy in the context of government contracting. So city of Richmond is an important point. The petitioners led off by talking about the Freedmen's Bureau Act. And I felt like your opening was scripted. So it's for the respondents. So it's okay to have a scripted opening, but specifically, one of the things that our team sort of do better along the rounds is they modify their opening statement in response to what the petitioners say. In other words, the petitioners were up there for 10 minutes saying things with the Freedmen's Bureau Act, and I thought you had some good arguments against it, and it might be useful to sort of just practice improvising your response. It's very hard to do, but I'm giving the advice because I think you're both very strong to sort of make it less scripted and react more to what you just heard. It's like, Your Honor, my friends on the other side cited the Freedmen's Bureau Act, but they were incorrect because of, you know, these other legislation that discuss race. Because then if you heard on rebuttal from Campbell and Gabriella, they opened up and said that, you know, you guys were wrong about remediation on, right? They hit you on that right away. So one of the tactics I think our stronger teams do when they go second, whoever goes first doesn't have that option. Whoever goes second should perhaps deviate from the scripted remarks to lead off with the specific points. Because by the time we get to the respondent round, the facts already settled. We know what the general issues are. You can use your time more effectively. That's one thing to keep in mind. Let's see, for petitioners, you know, it's a really hard question when I ask you what happens if a campus is all white and Asian, right? There's not a good answer to that question. And at sometimes you have to sort of just take the punch and say yes. I'm sure you've all listened to the argument at the Supreme Court, and Justice Kagan was just wailing on the lawyers for the students of fair admissions. It's a friend of mine named Cam Norris, and he was just getting wailed on, right? It's like, so, okay, we have a campus that's all white. Are you okay with that? Yeah, no problem, right? You know, basically, because once you can see that, and for the other side, sort of line drawing issue you have to think about is 25 years, right? Will this ever end? And I think either Jeevan or Jack, I can't remember who, said that yes, there will be a logical ending point. I wouldn't be so quick to make that concession, because once you say there will be a logical ending point, I'll say, why haven't we reached it now? You say, well, I can't tell you why. Okay, so then you have this issue of deference, right? Then going back to petitioners, I think the hardest question I asked you, and I don't have a good answer, is how do you write this opinion? And I suspect there's some very smart law clerks right now scrambling on that exact question, because you say race cannot be used, period. Okay, and I just ask you a follow-up, so race can be used a little bit. And then the issue of how, if you eliminate the checkbox, how can you still use race in the context of the essays? I think it's actually a really hard question. I don't know there's a good answer. And whatever rule the court comes out with in June, or whenever they come out with the opinion, is going to be contested by the lower courts. All right, that's all I got. What questions do you have for us? You might be on mute, Campbell.
I don't think we have any questions. Just thank you so much for your time this morning.
This
We
was
appreciate
amazing.
it.
Jack and Javoon, this was an honor to go against you guys. You were great. And thank you,
Oh.
judges. It was a really great round.
Thank you.
That is
Jack
all.
and Jeevan, do you have any questions you want to ask?
I don't think so. Thanks for the opportunity. It was great to compete, and yeah, thanks.
Are you still thinking about law school?
Sort of. I don't know.
You don't know? But what years are you?
I'm a sophomore, so I got time.
Yeah, time.
I'm a junior. So
I see, a little bit more time. All right. Well, if you have an interest in law school, whatever, you know how to reach out to me. If you're ever in Houston, come visit my class. But hopefully we can visit soon enough. All right. Dallas or Kathleen, anything else you want to add?
No, good luck to you guys.
Yeah, good luck.
All right. Thank you so much. We'll have the scores posted probably by tomorrow, if I had to guess. well, I got like 5 more rounds to go today. It's an all day thing, so almost there. All right, everyone, teams can please sign off. I'll talk to the judges for a few moments and I'll turn off the recording now. Thank you so much.